those conversations. It doesn't. You're willing to take that risk because some great stuff's going to come out of it, and you like the people that you're collaborating with, and you have trust with them. The law assumes people are untrustworthy and that you need to have something in writing to make them toe the line. But, you know, I have great friends from grade school, and if we started a business together, it would probably work out fabulously. But the law doesn't assume that. The law is looking at what happens when things go bad. What happens when they get divorced? What happens when they break apart? What happens when this is the Facebook dude and the movie? I mean, seriously, if they'd had agreements, that some of that movie wouldn't be what it was. Right? Connect You or whatever those guys were, they would have had something to enforce.
So it's not conducive to innovation, is what you're saying?
The law isn't as conducive to innovation as you'd like. In fact, patent law thinks about innovation as if you were working at the DuPont company in 1930, and we were doing a lot of trial and error and writing down that trial and error in your lab notebook and having two colleagues down the hall witnessing for you. Okay?
That's scary.
And that's not modern innovation, but if we had to prove who was first to invent, the patent office is looking, where's your lab notebook? So, you know, maybe take from that, keep a journal, and just keep something as a data journal so you know what we talked about with people. I hate to say I don't trust people, I'll write a diary because I don't trust people, but that can help you. A contemporaneous record of what you were doing will really help you. Yeah.
I was just curious along those lines, how likely is it, do you think, if patent law is so out of date, if it thinks in terms of 1930s lab notebook, you know, how likely do you think reform is?
Actually, it's getting closer than we may all expect. For 5 years, they've been trying to change our patent law to a first to file the patent application gets the patent. Currently, the law is the first to invent. And how we define who's the first to invent. You have a conception of the invention. Somebody had to think of it, and then someone has to reduce it to practice. It can be the same person, but it can also be a team of people. And a reduction to practice can either be you actually made one and proved it worked, or it can be you drafted a nice patent application with enough detail that someone could build it. Okay? So, how do we prove conception? How do we prove reduction to practice? The law right now looks for where's your lab notebooks. Okay? But if we change to a first to file the patent application, we're not going to worry about who was first to think of it or who was first to reduce it to practice. It's now going to be a race to who's gotten to the patent office first. That may be a good thing because right now the U.S. is the only country that uses first to invent as our standard. Everywhere else is first to file. It's possible to have somebody else own the patent rights everywhere but the U.S. And that's a discontinuity that perhaps isn't tolerable. But if I thought about the contest for who was first to invent, it's a very small percentage where the first to file also, the first to file did not win. They usually win because it's so hard to prove, you know, where's the lab notebooks? It's very hard to prove that conception.
My disclaimer is, Conley Both are the lawyers for my startup and they're great guys.
And my disclaimer is I'm not giving specifically
legal advice, blah, 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 blah.
Giving you generalities.
So Zach has proven that the current IP law is an inhibitor to innovation. You've just proven that the only reform that's on the table would benefit lawyers because it would make us pay quicker for lawyers, as opposed to just being the first to invent. We'd have to actually write a check to a law firm before it does it.
No.
My question is, when we're thinking about what actually gets patented, so last week Apple called off the patent trolls on all of the app developers because there was a patent on how you get the in-app ads.
Right.
Amazon, in some way, shape, or form, patented the one-click payment.
Yes, yes.
When we think about what's protectable, how finite and how, I mean, one-click payment seems to me to be just a feature, but they've been able to patent it and they've, well, exactly, but no one else can use it without paying Amazon. So what should we be thinking about from this? It's not just our business we're patenting, there are components of process and other things that are available.
To that point,
Yeah.
Jay, because I think he's actually bringing up a really big point. You're going down the road of impact. How much of an impact to what is, that possibly to what is not? How much is it going to be what we're dealing with that much more impactful to
I'm
that?
losing you, Ivan, I'm losing you.
Well, no, the thing is that what I'm trying to bridge here is the fact that Jay was saying that little button that Amazon had created a huge impact, although it was a very small little piece.
Well, I think it's important to realize that, I mean, I think we're all pretty aware that if we steal a photo off another website, we don't really own it.
Right.
If we copy text, we probably don't own it. A name that looks the same or a mark that looks the same. But something like the one-click sale button, which I may be like, that's a great feature, I gotta put it on my website, and all of a sudden I get a letter from Amazon saying, by the way, you owe us money. So what should we be thinking about? What are the sizes and the different types as we look at technology?
All right. Well, I'm not going to give you an it depends, but it depends. The standard for what is patentable is anything made by man, and I'd say, or woman, but the standard is anything made by people can be the subject of patents. The law hemmed it in a little bit because in software implemented inventions, you have to show machine implementation or a transformation of matter. So you can't take an accounting system and just put out the steps of how you keep your books without saying it's implemented by a computer, okay? But beyond software, you can have patents on processes, on compositions, on new medicines, on articles of manufacture. I guess I brought a couple sample patents of mouth guards, like athletic mouth guards. And I mean, it's, if you want to.
Yeah, you can pass
Yeah,
those around.
that's what my.
But you can protect the ornamental appearance of a useful object as a design patent. So if you have a unique, I don't know, unique mouse, unique water bottle, I mean, we got a lot of things that are design specific that can be protected. Machines. My colleagues in here probably will give you other examples after we're done. It can be anything that is useful, new, meaning not done identically before, and not obvious. Well, that's where patent attorneys are their key. Because once you know the problem, maybe the solution is evident, maybe not. So what is obviousness? Well, are you doing something that would be expected by persons working in the field? Or are you doing something a little different? As soon as you have the thought, you know, this is a little different, you should think about how we're going to protect that. So as soon as you're not taking the normal path, stop and think, okay, maybe I can protect it. But in terms of risk avoidance, it is a risky world out there. We do freedom to operate opinions. If a client is coming in with, I want to launch this new product, we search for patents that will impact that launch. And we'll look and see if there's risk associated with launch. And sometimes there may be some risk and the client's willing to accept that, and sometimes there's something we can't find in our search because it pops up later. So there's no perfect one answer. So I like intellectual property because it is such a challenge, and we get to look at new things and we get to look at different things all the time. But I think you, from the client side, you want certainty, and we can't give you 100% certainty. We can give you, you know, here's the risk. You decide if you want to accept that.